Major breaking news out of the United States Court of Appeals for the First Circuit. We have another terrible, although expected decision in an arms ban case. Specifically, a 3-judge panel upheld the Rhode Island ban on quote-unquote large-capacity magazines, i.e. magazines that hold more than 10 rounds, in the case of Ocean State Tactical versus Rhode Island. This was not a shock because the United States Court of Appeals for the First Circuit is literally the worst court in America for the Second Amendment. There is no combination of 3 judges that you can possibly get that would somehow uphold our Second Amendment rights. And we're going to talk all about that. But what's shocking to me is the sloppiness of the reasoning. Arguably, the fraudulent nature of some of the reasoning, which we'll see what I'm talking about when we get back. And I'll let you make a decision as to whether or not you think my opinion is correct. Stay tuned. We're going to talk all about it in 1 second. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarm: What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, in the case of Ocean State Tactical versus the state of Rhode Island enacted a quote-unquote large-capacity magazine ban. This is a magazine case that says that magazines that hold more than 10 rounds are basically banned in the state of Rhode Island. And there was a motion for a preliminary injunction that was made. Obviously, it was denied by the district court. It went up to the United States Court of Appeals for the First Circuit, which is the federal appellate court out of Boston, Massachusetts. And to no one's surprise, in a 3-0 decision, the Court of Appeals upheld the denial of the preliminary injunction. Their reasoning was absolutely sloppy and arguably disingenuous and maybe even worse. And I'm just going to start off with the best example of this right up front. As you know, in the Nysurpa versus Bruin case, it talked about and reaffirmed the decision of Heller versus the District of Columbia, 2008 Supreme Court decision. Just to remind you, the Heller case in 2008 said that in arms ban cases, the question is whether or not an arm is in common use by Americans for lawful purposes, period, full stop. That is a critical question. The historical analog law they looked to was laws that prevented the carrying of dangerous and unusual weapons. And they indicated, of course, as they did reaffirmed in Bruin, that the burden is on the government when you're dealing with the historical, the justification of these laws based on history. Well, there's no doubt that a magazine is an arm. The Court of Appeals here acknowledged that was an arm and conceded that for the purposes of the argument here, that it was an arm, and nevertheless went on to misanalyze and uphold this anti-gun law. And the best evidence that there's a problem with this decision is right up front. Because if you look on page number 10, this is what they write. And then I'm going to show you what the actual language in the Supreme Court precedent of Bruin is about the Heller arms ban test case of in common use. This is what the First Circuit wrote today. This lack of directly on-point tradition does not end our historical inquiry, but it does affect our mode of analysis. The Supreme Court has instructed that cases like this one, quote, implicating unprecedented societal concerns may require a more nuanced approach to historical analysis. Okay, you see that language there? Let me give you the actual full sentence in the Bruin case. Notice how in that language they took a part of a sentence out? That's what the ellipses are, the ... Guess what? They omitted some critical information. Let me tell you if this, I'm going to show this to you and you tell me if it would impact the outcome of this case. This is what Bruin actually said when you put the full sentence together. Here it goes. While the historical analogies here, that's Bruin, and in Heller, that's an arms ban case, are relatively simple to draw, other cases, other other than Bruin and Heller, other cases implicating unprecedented societal concerns or dramatic technological changes may require a more nuanced approach. Bing, 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 bing. Did you see what I just did there? You see what happened? They took a part of the sentence, and they cut out on purpose the critical qualifying language of the start of the sentence. This is that while historical analogies here and in Heller are relatively simple to draw, other cases implicating unprecedented societal concerns may require a different mode of analysis, meaning looser analogs. So here's the key. The First Circuit Court of Appeals in this Ocean State Tactical case is dealing with an arms ban case. This case is, can you ban magazines that hold more than 10 rounds? And that is an arm because they acknowledge this is an arm, but even if you assume for the sake of argument that a magazine in and of itself is not an arm because it's an essential component of a firearm in the same way that ink is an essential component of the First Amendment's right to free speech and right to free press, which is protected by, among other things, the Minneapolis Star case, even though the word ink doesn't appear in the text of the First Amendment. Whether you want to say a magazine is arm or not, even though this court said we're assuming that it is an arm, keep in mind that a magazine ban, listen carefully, a magazine ban that bans magazines that hold more than 10 rounds is the equivalent of a gun ban case. How so? By banning magazines that hold more than 10 rounds, you have effectively banned all firearms in that state that are capable of firing more than 10 rounds without the need for manually reloading. So by banning magazines that hold more than 10 rounds, you not only have banned the magazines that hold more than 10 rounds, which in and of itself is a ban of arms, you've also banned firearms capable of holding more than 10 rounds, which is a firearms ban, just like Heller. Both instances are arms ban cases. And has the Supreme Court ever decided an arms ban case? Yes, of course they have. That was the entire case of Heller. They've already done the work. They've come up with a constitutional test. And what they've said at a minimum is, if an arm is in common use today by Americans for lawful purposes, it cannot be banned. But you see how this First Circuit Court of Appeals cut off the sentences. Now, in the old days, no one might have caught that. But you're not going to slide that stuff by the Four Boxes Diner. Not going to happen. I'm sorry, you law clerks up there, you judges up there in Boston, not going to happen. We're going to catch you when you play games like this. And sloppy reasoning. Why did you not? Why? And let me ask you this. Why did the court decide the need to not type in the entire sentence and publish it? Why? Why did it cut off the critical operative thing? Because we know why. The relevant language they cut off and conveniently omitted basically made it clear that what they were about to do was unconstitutional and illegal and violated Supreme Court precedent. And then what did they do after they mouthed these words, which they should not have done, improperly? They then went on and did a whole host of interest balancing and said that there's all this evidence that magazines that hold more than 10 rounds are bad and contribute to mass shootings and all sorts of things. So they did exactly what you're not allowed to do in Bruin and Heller, which is this interest balancing of the good and the bad of guns. And they tried to justify it. How? How did they get to that point? They tried to justify it by saying, well, this is an unprecedented societal concern involving these magazines. This is dramatic technological change of some sort with these magazines. But again, that question has already been decided with the constitutional test, and they simply pretended it did not exist, and then they went on and did interest balancing, which is a total no-no. And to make things even worse, they went on to say that in Heller, right, then it goes on to misread Heller in a different way. In addition to rejecting the common use test and the dangerous and unusual standard that we've talked about as the historical benchmarks, which we discussed repeatedly, it then treats as significant that Heller explained the reasons why handguns might be useful and acts like that was an invitation for the First Circuit today to go out and assess whether or not magazines are helpful for self-defense or whether magazines help criminals or any of this stuff. But of course, that again misreads Heller, because if you look at the Heller case specifically, let's see what it specifically says. It is no answer to say, as petitioners do, that's the District of Columbia, that it is permissible to ban the possession of handguns so long as the possession of other firearms, i.e. long guns, is allowed. It is enough to note, as we have observed, that the American people have considered the handgun to be the quintessential self-defense weapon. There may be many reasons that citizens may prefer a handgun for home defense. It is easier to store in a location that is readily accessible in an emergency. It cannot easily be redirected or wrestled away by an attacker. It is easier to use for those without an upper body strength to lift and aim a long gun. It can be pointed at a burglar with one hand while the other hand dials the police. But here's the key language, folks. This is what the Supreme Court wrote in Heller. Whatever the reason, handguns are the most popular weapon chosen by Americans for self-defense in the home, and a complete prohibition of their use is invalid. So there you have it. The Supreme Court basically said it doesn't matter why Americans decide this is a great weapon for them. As long as they've done it, it cannot be banned because it's not dangerous and unusual, because if it's in common use, it's not unusual. That is the Supreme Court holding in Heller, which is how they struck down the handgun ban of D.C. And yet this court simply ignores all of that and immediately engages in interest balancing and tells a bunch of stories about how magazines can be misused. But here's the kicker, folks. You want to play statistics for just one moment? Let's just step back for 1 second and think about this. If you want to just talk about statistics, there is no doubt that the one firearm-related item in America that is most often used by criminals is the handgun. In 2008, the Supreme Court says it doesn't matter that the handgun is mostly used by criminals because we don't measure constitutional rights by how they can be misused. So if it's true that a handgun, which is the most popular choice by criminals of all the firearm-related devices to commit crimes with, if that is protected under the Second Amendment, there is no doubt through the principles of a fortiori, which is true for the lesser, it's obviously also true for the greater, through the principles of a fortiori, that you can't ban things like AR-15s and magazines that hold more than 10 rounds. Because handguns have already been argued by the anti-gun movement that those are the most dangerous weapons used by criminals the most of the time. And the Supreme Court said it doesn't matter. And last but not least, none of this required any kind of factual hearing or trial, because as a reminder, in the Heller case, when they decided that handguns are protected arms, there was no trial, there was no evidence, none of that stuff. It was all legislative facts. It was all understood. This is all common knowledge. They didn't have to have trials or any of this stuff. So the bottom line here is that the United States Court of Appeals simply was pathetic with this decision. And you know, the truth is, they don't care, because they don't care about you. They don't care about the Second Amendment. They want you disarmed because you're a peasant, you're a serf, you're a subject. You don't get fundamental rights. And I can tell you, if you try to walk into that courthouse in Boston that cost, last I checked, like $250 million, back when $250 million was a lot of money. Thank you, Stephen Breyer, for helping build that beautiful house that cost taxpayers infinite money down there in Boston. But set that issue aside. The bottom line is, I can assure you, when you walk into that courthouse and you talk to the law clerks and you talk to the judges and you go into those courtrooms, trust me, they are protected with men with firearms and women with firearms, the same types of guns and the same sorts of magazines that they think you don't deserve to protect yourself with because you are not good enough. You're a peasant, you're a peon, you're not an up-high fancy judge, also known, in my view, when it comes to the Boston courts and the U.S. Court of Appeals, also known as politicians in black robes, as far as I can tell with this decision. Nevertheless, that's where we are, folks. We'll see what happens. I'm not sure whether or not there'll be a petition for cert or not. I guess only time will tell. I will report on this. In the meantime, I will put a copy of this opinion down below. You can check it out to see if you disagree, see if I'm being unfair, but I don't think I am, and that's where we are. Okay, folks? Hope you learned something here today. Make sure you subscribe to X at 4 Boxes Diner and follow me here as well, and we will see you again soon at the 4 Boxes Diner.
Orders up. Table 2A.